UPSC CSE English. We'll start today's topic, fundamental rights, in our crash course Inspire for upcoming prelims 2021. Unacademy, India's largest e-learning platform, will give you option to choose various subscriptions where you will get daily live classes, mock test, structured courses and unlimited access for live and recorded classes. We 100 plus top educators will guide you throughout the preparation. Yes, good evening, good evening. Yes. Right. So download Unacademy learning app today and start your preparation. It's me, Rushikesh Inamdar, having experience more than 8 years in the field of UPSC, and I'm guiding UPSC aspirants. You can join our Telegram group to get daily updates. You can start your preparation with different modules like history, current affairs, geography, Indian economy, science tech, ecology, environment according to your choice. Do not forget to use code RBI Live to get 10% discount on your subscription on Plus or either Iconic. In this Iconic subscription, you will get benefit of personalized feedback, personal coach. You can use my code, referral code RBI Live, to get 10% discount. Yes, aspirants, according to your convenience, you can join our batches for 1 year, 2 year, weekend batches or NCRT batches. Right now, those candidates wants to upgrade their subscription, they have option and time till 31st January. Please upgrade your subscription into Iconic one. Now, this is the combo for the UPSC Civil Services Optional and UPSC CSE General Studies Plus and Iconic subscription. You can opt for that for 1 year, 2 year or 3 years as well. Right. Do not forget to use code RBI Live to get 10% discount on your subscription. So we'll start our today's important topic. If I'm talking about this particular module or heading, fundamental rights, which is most important part for your prelims as well as main examination. Right now, if we are talking about generally fundamental rights, yes, Aman, tell me what is meant by fundamental rights? Yes, yes, Ramkumar, tell me what is meant by fundamental rights? Yes, good evening, everyone. Good evening. So, the fundamental rights, according to its name, we are saying fundamental rights because they are guaranteed and protected by the Constitution of India. Alright, so basically fundamental rights are guaranteed and protected by the Constitution, and which is the fundamental law of the land. Alright, which is the fundamental law of the land. Now, why we are saying fundamental, why we are using word fundamental? Because in the sense they are most essential. They are most essential for the all-round, yes, for the all-round development of the individual. If I'm talking about any person A, so fundamental rights are essential for the development of the individual if we are talking about materialistic, intellectual, moral and spiritual development. Right. Now, next part, if we are talking about our constitution, so fundamental rights mentioned in the part 3. Alright. So, these are the mention in the part 3 of our constitution. Now, we'll see throughout the course like part 3, part 4 and part 4a. These are the important parts like fundamental rights mentioned in the part 3, DPSPs mentioned in the part 4 and fundamental duties mentioned in the part 4a. So we'll study accordingly. So just remember these are the 3 important parts of our constitution because they are providing or the basic idea of our constitution like liberty, justice and equality. All these things are under this 3 parts we will discuss and all the provisions under these parts. Right. Now we'll start the fundamental rights, that is part 3. So under the part 3 of the constitution, article 12 to 35 deals with the fundamental rights. Alright, so all these fundamental rights described in part 3 under article 12 to 35. Alright guys, now after the details of fundamental rights, we'll see the constitutional provisions. Right. Now under these provisions, part 3 of the constitution is rightly described as the Magna Carta of India. So see the term Magna Carta guys. What is meant by Magna Carta? So Magna Carta is the Charter of Rights. So it's Charter of Rights issued by King John of England. By King John of England in 1215. Alright. So Magna Carta are basically is the right Charter of Rights issued by the King John in 1215, right, under the pressure of the barons, and this is the first, remember guys, the Magna Carta is the first written document, written document related to fundamental rights of the citizens. Alright, now after that part 3 of the constitution is described as the Magna Carta of India. After the information of Magna Carta and Magna Carta of India, will study further part. So this part, it contains a very long and comprehensive list of justiciable fundamental rights. Alright, now the fundamental rights in our constitution are more elaborate than those found in the constitution of any other country in the world. If I'm talking about the all constitutions in the world and with reference with the fundamental rights in our constitution, fundamental rights are more elaborate, okay, in extensive form. Right, now the fundamental rights are guaranteed by the constitution. As I told you, the meaning of fundamental or fundamental rights are guaranteed by the constitution to all persons without any discrimination. Alright, so without any discrimination, fundamental rights are guaranteed by the constitution. Now, they uphold the equality of all individuals. Read the words properly guys. They, fundamental rights, uphold the equality of all individuals, then the dignity of the individual, the large public interest and unity of the nation. So these fundamental rights deals with the equality of all individuals, the dignity of the individual, and the larger public interest and unity of the nation. Right? Next, we'll see the fundamental rights are meant to promoting the ideal of political democracy. Alright, the fundamental rights are meant for promoting the ideal of political democracy. Now, they operate as limitations on the tyranny of the executive and arbitrary laws of the legislature. In short, fundamental rights aim at establishing a government of laws and not of men. So, it the aim of fundamental right establishing a government of laws. All right, so there is a government of laws along with these fundamental rights, we can say. Now, if we are talking about our enactment of our constitution, okay, so originally constitution, our Indian the Constitution of India provided 7 fundamental rights. Okay, but presently we have only 6 fundamental rights. So we'll see which fundamental right change into the legal right. Right. So now we'll see these 7 fundamental rights mentioned in our original constitution. Now, first, right to equality mentioned under Article 14 to 18. Yes, then definitely I'll describe all those things. Restrictions of fundamental rights. Don't worry. Keep patience. Yes, Swadesh. Wait. Be patient. I'll describe each and everything. Alright. Now we are just studying original 7 fundamental rights mentioned in our constitution. First is right to equality under Article 14 to 18. Then right to freedom under Article 19 to 22. Third, right against exploitation mentioned under Article 23 to 24. And fourth, right to freedom of religion mentioned under Article 25 to 28. Fifth right mentioned in the constitution was cultural and educational rights under Article 29 and 30. Right 6, right to property, Article 31. And next, right to constitutional remedies, Article 34. Now, in this 7, just remember right to property. Okay, so right to property was deleted from the list of fundamental rights by 44th Amendment Act. 44th Amendment Act 1978, and it is made a legal right under Article 300A in Part 12. Alright, now just remember, out of these 7, one right, that is right to property, was deleted from this fundamental rights list, and it made a legal right under Article 300A. Right? So there are only 6 fundamental rights. Alright, so first, right to equality. If we are talking about present condition, we have 6 fundamental rights: right to equality, right to freedom, right against exploitation, right to freedom of religion, cultural and educational rights, and right to constitutional remedies. Right? Now, next, features of fundamental rights. So, we'll see the features of fundamental rights in which, first, some of them are available only to citizens. Yes, now you will clear your doubt. That is, yes. Now, some of them are features of fundamental in which, first, what we can say, fundamental rights are available only to the citizens. Some of them, right? Some of them are available only to the citizens, while others are available to all persons, whether citizens, foreigners, or legal persons like corporations or companies. So, if we are talking about features, some of them are available to the citizens and other fundamental rights are available to all. Right? Now, they are not absolute. Here is the answer of your second query. That is, fundamental rights are not absolute but qualified. What is meant by that? Means the state can impose reasonable restrictions on them. So the state can impose reasonable restrictions on fundamental rights. However, whether such restrictions are reasonable, see the language of these rights. If we are talking about the fundamental rights, they are not absolute but qualified, and the state can impose reasonable restrictions on them, and such restrictions are reasonable or not is to be decided by the courts. Right? Now, next, third, all of them are available against the arbitrary action of the state. However, some of them are also available against the action of private individuals. If we are talking about fundamental rights, so they are available against the arbitrary actions against state, and some of them are available against the action of private individuals also. Alright, we'll see the details. Now, next feature is that some of them are negative in character, that is, place limitations on the authority of the state, while others are positive in nature. It means conferring certain privileges on the persons. Right? If we are talking about few negative and few positive fundamental rights, so if we are talking about negative, which means these rights place limitations on the authority of the state, and if we are talking about positive fundamental rights, which means they are providing certain privileges to the persons. All right, on the persons. Now, next feature is they are justiciable. Yes, guys. So they are justiciable, allowing persons to move the courts for their enforcement if and they are violated. Now, just read this clause once again. Yes. Yes, guys. So, these fundamental rights are justiciable, allowing persons to move to the courts for their enforcement if and they are violated. In case of these fundamental rights are violated, a person can move to the courts. Okay. Now, next feature. They are defended and guaranteed by the Supreme Court. Hence, the aggrieved person can directly go to the Supreme Court, not necessary by the way appeal against the judgment of the High Court. So, these fundamental rights in case of violation of fundamental rights, a person can directly go to the Supreme Court. Alright. So they are defended and guaranteed by the Apex Court of India. That is Supreme Court. Next, the Parliament can curtail or repeal them, but only by the Constitutional Amendment Act and not by an ordinary act. In case of any type of emergency or Parliament thinks to curtail these rights, then Parliament can curtail or repeal them only by the Constitutional Amendment Act. Right? Now, moreover, this can be done without affecting the basic structure. In case of Parliaments wants or they thinks to change or curtail or repeal these fundamental rights, they can do that amendment without affecting basic structure of the constitution. Alright, so remember this point under the features of our fundamental rights. Now next, next feature, they can be suspended. Yes, so there's definitely, I'll answer your query, just patience for that. We'll cover. Okay, yes. So they can be suspended during the operation of a national emergency, except the rights guaranteed by Articles 20 and 21. Okay, so these fundamental rights can be suspended during the operation of national emergency, except the rights guaranteed by Article 20 and 21. Now, 6 rights guaranteed by Article 19 can be suspended only when emergency is declared on the grounds of war or external aggression. That is external emergency. Not on the ground of armed rebellion or internal emergency. So, 6 rights guaranteed under Article 19 can be suspended only when the emergency is declared on the grounds of war or external aggression. Right? Not on the grounds of internal emergency. Now next, there is scope. So, scope of operation is limited by Article 31A, which savings of laws providing for acquisition of estates, and Article 31B, validation of certain acts and regulations included in the 9th schedule of Constitution, and Article 31C, which savings of laws giving effect to certain directive principles. Right. Next, members of armed forces, paramilitary forces, police forces, intelligence agencies and analogous services can be restricted or abrogated by Parliament under Article 33. Right. So these are the features of the fundamental rights. Now next, their application can be restricted. Fundamental rights can be restricted while martial law in force in any area. Martial law means military rule imposed under abnormal circumstances to restore order, right, which mentioned under Article 34. Now, so but this martial law or military rule is different from the imposition of national emergency. So military rule and national emergency, these are the different in nature. All right, so we'll discuss further all those things. Yes. Now next, most of them are directly enforceable, that is self-executory, while a few of them can be enforced on the basis of a law. So few rights are directly enforceable and few of them can be enforced on the basis of a law. Right now, such law can be made only by parliament and not by the state legislature, so the uniformity throughout the country is maintained. So if we are talking about fundamental rights and enforcement of these rights on the basis of law, only the state, only parliament, right? So only parliament can make law, not any state legislature. So this provision mentioned in the article 35. Next, after these features, we'll study definition of state. So what is mean by state? Yes, tell me, what is mean by state? So guys, the term state has been used in different provisions considering the fundamental rights. So article 12 has defined the term of the purposes of part 3, right? So article 12 has defined the term state for the purpose of part 3. Now according to it, the state includes the following. What is mean by state? So first, government and Parliament of India, that is executive and legislative organs of the union government. So what is mean by state? So state includes government and Parliament of India, that is executive and legislative organs of the union government. Second, state includes government and legislature of states. Government and legislature of state means executive and legislative organs of state government. Right? So, center, state. And third, all local authorities. So, that is municipalities, panchayats, district boards, improvement trust, etc. So state includes government and Parliament of India along with executive and legislative organs of the union government. Second, government and legislature of states includes executive and legislative organs of the state government. And third, all local authorities, that is municipalities, panchayats, district boards, improvement trusts. Along with that, the state includes all other authorities, that is statutory or non-statutory authorities like LIC, ONGC, SAIL, right? So remember, under the state term includes these authorities as well, that is statutory and non-statutory authorities. So state has been defined in a wider sense, so as to include all its agencies. Now, it is actions of these agencies that can be challenged in the courts as violating the fundamental rights. So all these agencies or all these part of the state, and if we are talking about the violation of any fundamental rights, so this can be challenged in the courts, okay, against these all agencies. Now, one of the judgment by Supreme Court, so according to the Supreme Court judgment, even a private body or an agency working as an instrument of the state falls within the meaning of the state mentioned in the Article 12, right? So even a private body or an agency working as an instrument of the state falls within the meaning of the state, which describes in Article 12, right? Now, next, laws inconsistent with the fundamental rights. Now we'll see laws with fundamental rights. Now we'll see Article 13. Correction. So Article 13. Article 13 declares that all laws that are inconsistent with or in derogation of any of the fundamental rights shall be void. Under Article 13, subclause 1. So, it declares that all the laws or all laws that are inconsistent with or in the derogation of any of the fundamental rights shall be void, right? In other words, it expressively provides for the doctrine of judicial review. Alright, now this power has been conferred on the Supreme Court, Article 32, and the High Courts under the Article 226 that can declare a law unconstitutional and invalid on the ground of contravention of any of the fundamental rights. Alright, now yes. So, Article 13, Clause 1 declares that all laws that are inconsistent with or in derogation of any of the fundamental rights shall be void. Now, next. The term law in Article 13 has been given a wide connotation so as to include the following, right? So, first, permanent laws enacted by the Parliament or the state legislature. Second, temporary laws like ordinances issued by the President or the state governors. Third, statutory instruments in the nature of delegated legislation, executive legislation like order, bylaw, rule, regulation or notification, right? So non-legislative, next is non-legislative sources of law, that is custom or usage having the force of law. Now if we are talking about these laws with the fundamental rights under Article 13, which given the wide connotation, that is permanent laws, temporary laws like ordinances, statutory instruments, non-legislative sources of law. So not only a legislation but of the above can be challenged in the courts as violating fundamental rights, hence can be declared as a void. Alright, now Article 13 declares that a constitutional amendment is not a law, hence cannot be challenged. Mentioned in Article 13 Clause 4 added by the 24th Constitutional Amendment Act. However, the Supreme Court held in the Keshwananda Bharati case 1973, they override or they just gave a judgment that constitutional amendment can be challenged on the ground that it violates a fundamental right that forms a part of the basic structure. In that case of Keshwananda Bharati case 1973, Supreme Court said that constitutional amendment can be challenged on the ground that it violates the fundamental right that forms the part of the basic structure of the constitution, so can be declared as a void, that particular amendment, right? So this is the important decision marked by the Supreme Court. Next, we'll see first right, that is right to equality. Yes guys, right to equality. So in this right, we'll see first equality before law and equal protection of laws, right? So article 14 deals with this clause, that is, state shall not deny any person equality before the law or the equal protection of the laws within the territory of India. So this provision confers right on all persons, whether citizens or foreigners. Right. Now, the concept of equality before law, if we are talking about the term equality before law, is derived from British Constitution, and equal protection of laws has been taken from American Constitution. If we are talking about this clause, equality before law and equal protection of laws was derived from British Constitution and American Constitution respectively. Right. Now, under this right to equality, the first concept is described as the absence of any special privileges in favor of any person. So there are no any special privileges or norms for favoring any person. Now, the equal subjection of all persons to the ordinary law of the land administered by ordinary law courts. And third, no person, whether it rich, poor, high, low, official or non-official, is above the law. It means a person, for example, if we are talking about any person, like if for example he is the member of any below poverty line, we can say the citizen belongs to the below poverty line, or person belonging to a business family, that is we can say rich. So no person is above the law. So particular, if we are talking about our law, is equal for both entities, right? Both person. So there is no any discrimination. Next, in second concept of equality, the equality of treatment under the equal circumstances, both in the privileges conferred and liabilities imposed by the laws. Second, the similar application of the same laws to all persons who are similarly situated, and like should be treated alike without any discrimination. Thus, the negative concept, and if we are talking about these two concepts, that is equality before law and equality protection of laws, in negative and positive in nature, right? So these both have, and the both of them establishing equality of legal status, opportunity and justice. Now Next, Article 14. Article 14 forbids class legislation. It permits reasonable classification of persons, objects, and transactions by the law. But the classification should not be arbitrary, artificial, and or evasive. Right? Now, rule of law. The concept of equality before law is an element the concept of rule of law pronounced by A.V. Dicey, the British jurist, and in his concept there are three elements and aspects mentioned, like under the rule of law, absence of arbitrary power, that is, no man can be punished except for a breach of law. So, a person can be punished in case of only a breach of law. If a person can violate any law or rule, then he can be punished. Right? Now next, equality before the law, that is equal subjection of all citizens, as we have discussed, to the ordinary law, the land administered by the ordinary law courts. So equal treatment should be, or all citizens equal in front of the law. Right? Now the Dicey observed, no man is above the law, but every man, whatever be his rank or condition, is subject to the ordinary law of the realm and amenable to the jurisdiction of the ordinary tribunals. For example, a person is a president, or a person is working in any or performing any low responsibility, both they are same in front of the law when they are breaking or violating any rules or law. Now next, the primacy of the rights of the individual, that the constitution is the result of the rights of the individuals as defined and enforced by the courts of law. Now, if we are talking about the three observations of Dicey, first two elements applicable to the Indian system, and the third one, this one is not applicable, because if we are talking about our Indian constitution is the source of the individual rights, right? So first two observations and elements applicable to our Indian systems. Now, if we are talking about our Supreme Court held that the rule of law as embodied in Article 14 as a basic structure. So just note down this point. The rule of law embodied in the Article 14 is a basic structure of the Constitution. Now next. Now under next heading, exception to equality, we'll see few terms mentioned under this exception to equality. So the rule of equality before law is not absolute, and there are constitutional and other exceptions to it, right? For example, if we are talking about these exceptions to equality, that is, the President of India and the Governor of State enjoy the following immunities under Article 361, in which the President or the Governor is not answerable to any court the exercise and performance of the powers and duties of office. Next, no criminal charges or no criminal proceedings. No criminal proceedings shall be instituted or continued at the president or the governor in any court during his term office. So during his terms, no criminal proceedings will be continued or instituted. Right now, third, no process for the arrest or imprisonment of the president or governor shall be issued from any court during his term of office. Right. So these are the exceptions. Along with next exception is no civil proceedings against president or the governors instituted during his term of office in any court. Right. Now next, no person shall be liable any civil or criminal proceedings in any court in respect of the publication in a newspaper. These are we are talking about exceptions. No member of parliament shall be liable to any proceedings in any court in respect of anything said or any vote given by him in parliament or any committee thereof, mentioned under Article 105, deals with the empowering the member of parliament with these proceedings. Right now, next exception is no member of legislature of a state shall be liable to any proceedings in court in respect to anything said or any vote given by him in the legislative or any committee mentioned under Article 194. The same things like member of parliament and member of legislative assembly and councils. These are the exceptions. Next, Article 31C. So, dear friends, Article 31C is an exception to the Article 14. Means it provides that the laws made by the state for implementing the directive principles contained in clause B or clause C of Article 39. So cannot be challenged on the ground that they are violative of Article 14. So the Supreme Court held that where the Article 31C comes in, Article 14 goes out. It means if we are talking about Article 31C entered, then Article 14 goes out. Okay. Just remember this single line related with this exception. Now next exception is the foreign sovereign rurals, ambassadors and diplomats enjoy immunity from criminal and civil proceedings, and the United Nations organization and its agencies enjoy diplomatic immunity. Right. So these are the exceptions mentioned under these clauses. Now next, right to equality, in which we'll see next point, that is prohibition of discrimination on certain grounds. So Article 15, if we are talking about Article 15 dealing with this prohibition of discrimination on certain grounds. Right. Now Article 15 clause 1 provides that state shall not discriminate against any citizen on grounds of only on religion, race, caste, sex or place of birth. So as we have seen many times, the state shall not discriminate against any citizen on grounds of religion, race, caste, sex or place of birth. Right. Now the word discrimination means to make an adverse distinction with regard to or to distinguish unfavorably from others. And the use of word only connote that discrimination on other grounds is not prohibited. Right? Now, prohibition of discrimination on certain grounds, in which Article 15 describes these clauses. Now, next. Article 15 Clause 2 says that no citizen shall be subjected to any disability, liability restrictions, or condition on grounds only of religion, race, caste, sex, or place of birth with regard to 1. Access to shop, public restaurant, hotels, and places of public entertainment. B. The use of wells, tanks, bathing arts, road, and places of public resort maintained wholly or partly by state funds or dedicated to the use of general public. Right. So, under this prohibition of discrimination on certain grounds, we have studied these clauses. So, you can revise these clauses, guys. Right. I can understand when we are just studying first time, it seems to be difficult, but these, when you will revise all those, right, and these articles, definitely you will remember all those things. So, next. Under this, there are 4 exceptions to this general rule of non-discrimination. So, now we'll study exceptions to this general rule of non-discrimination, in which first, the state is permitted to make any special provision for women and children. For example, reservation of seats for women in local bodies and provision of free education to children under Article 15 Clause 3. These are the 4 exceptions, in which first is to make any special provision for women and children. Next, the state is permitted to make any special provision for the advancement of any socially and educationally backward classes or citizens, classes of citizens, or for the scheduled caste and scheduled tribes, for SCs and STs under Article 15 Clause 4. So, reservation of seats and fee concession in public educational institutions. Third one, state is empowered to make any special provisions for the advancement of any socially and educationally backward classes, which deals and mentioned in the 93rd Constitutional Amendment Act 2005. Right. Next, the state is empowered to make any special provisions for the advancement of any economically weaker sections of citizens. So these are the exceptions. Right. Now next, state is allowed to make provision for the reservation of up to 10% of seat for such sections like economically weaker sections in admission to educational institution, including private educational institutions, whether aided or unaided by the state, except minority educational institutions. So reservation is valid and mentioned in these clauses of our constitution. Now, what is the purpose of this reservations? It means the economically weaker sections would be notified by the state from time to time on the basis of family income and other indicators of the economic disadvantage. Okay, so I mean to say the members belonging to this economically weaker sections will get opportunity to study and for the education as well. Now third equality of opportunity in public employment. So Article 16 deals with that, equality of opportunity for all citizens in matters of employment, right? So there is no any citizen can be discriminated, right, for that employment on the grounds of religion, race, caste, sex, descent, place of birth or residence. So under Article 16 clause 2 mentioned equal opportunity in public employment. Now if we are talking about the exceptions to this general rule of opportunity in public employment, in exceptions, point 1, Parliament can be prescribed residence as a condition for certain employment or appointment in a state or union territory, local authority or other authority. So the public employment requirement as to residence, Act of 1957 expired in 1974. There is no such a provision for any state except Andhra Pradesh and Telangana, mentioned in Article 16 clause 3. Next, the state can provide for reservation of appointments or posts in favor of any backward class that is not adequately represented in the state services under Article 16 clause 4. Now, next exception is a law can provide the incumbent of an office related to religious or denominational institution, right? Next exception, the state is permitted to make a provision. The state is permitted to make a provision to reservation of up to 10% of appointments or posts in favor of economically weaker sections of the citizens, right? Now this reservation up to 10% would be in addition to the existing reservation. So economically weaker sections would be notified by the state from time to time on the basis of family income and other indicators of the economic disadvantage. So these are the powers with state, right? Now next, abolition of untouchability. So Article 7 deals with this abolition of untouchability, right? So untouchability and forbids its practice in any form. So Protection of Civil Rights Act 1955 to enlarge scope and make penal provisions more stringent. So Article 17 deals with the abolition of untouchability. So the Act defines civil right as any right occurring to the person by reason of abolition of untouchability under the Article 17. So the term untouchability has not been defined either in Constitution or in the Act. So it refers to the social disabilities imposed on certain classes of persons by reason of their birth in certain castes. So the Supreme Court held that the under Article 17 is available against private individuals also. It means constitutional obligation of the state to take necessary actions to ensure that this right is not violated, which is Article 17. Next, abolition of titles, right? Now Article 18 deals with the abolition of titles, in which it prohibits the state from conferring any title except a military or academic distinction, right? Under the article clause 18A, abolition of titles, this right prohibits a citizen of India from accepting any title from any foreign state mentioned in the article 18 clause 2. Next, a foreigner holding any office of profit or trust under the state cannot accept any title from any foreign state without the consent of the president mentioned in the article 18 clause 3. And next clause, that is, no citizen or foreigner holding any office of profit or trust under the state is to accept any present emolument or office from or under any foreign state without the consent of the president mentioned in the article 18.4. Right now, so guys, we have studied article 14 to 18. We'll cover further fundamental rights in the next lecture. So dear friends, you can revise all those articles. If you have any doubt, you can join our group on Telegram. You can ask your doubts and keep studying and revising what we have studied in this lecture. And dear students, you can join Unacademy Combat as well, which scheduled on 31st January and 7th Feb in the morning 11 a.m. So till the time, just revising what we have studied.